Well, let's again talk about a subject that I actually hope you're never on either side of this issue. And in the banking world, I was always on the one side of it anyhow, trying to collect debt. But it's a procedure to handle debt when there's an inability to pay. And while it might surprise you, even though I had to go to bankruptcy court and deal with people that filed bankruptcy fairly often, I'm still an advocate for bankruptcy. I don't think that people would take chances, entrepreneurs and whatnot, if they in fact didn't have an out, and so I'm kind of, I hated it when I had to try to collect from people that filed bankruptcy, and some people definitely abused the practice. There's no question about that, but people wouldn't take chances, if they didn't have that as an option. So filing, right, can be voluntary. Everyone, I never knew any that were really involuntary. Now, we had debtors that were pushed by us and other creditors that ultimately filed voluntarily. I suppose had they not, they might have been pushed by us into involuntary bankruptcy. Creditor must be owed $2,300 plus in order to collect, I guess if they're an individual. So, and we'll talk about the various chapters, but there's Chapter 7, Chapter 13. There's also Chapter 11, which deals more with businesses, and we'll talk about that. The 2005 change was a big change, actually. It forces above median income earners to adjust rather than to liquidate. What was happening prior to that is folks, high earners, especially doctors and lawyers even, they'd get a lot of unsecured credit cards and whatnot, and they'd run them up. This is where some of the abuses came in, and they'd file for bankruptcy. And those were unsecured debts that would then be eliminated in those cases because they were unsecured. And the court said, nah, or not the court, the law said, or the Congress said, they passed a law and the president signed it, said, if you've got a high capacity to repay, we're going to allow the judge to move that over into a Chapter 13 adjustment and let them figure out a payment schedule so you'd still be paying. Technically, there is a trustee that's put in place. A lot of the ones that I saw was called a debtor in possession, where the debtor was still the trustee, basically. They do have priority classes. They go by secured, and then unsecured, and what types of debts they were, etc. So, discharge a further obligation by debtor to creditor in some cases, but some cases certain debts cannot be discharged. And again, just like we said with the high earners, could be all the debts might not be dischargeable, but you could still go through a bankruptcy, which is a 13 in that case. Here we go. It gives a fresh start, right? Chapter 7 is liquidation, and Chapter 7 involves businesses or individuals. Okay, and it's liquidation, meaning that technically all the assets, those that they can't exempt for individuals, businesses, there would be no exemptions, but individuals, those that they can't exempt are going to be liquidated or sold and used to pay off debts. Okay, fairly common. A lot of them that we had were Chapter 7. Chapter 13 is the wage earners plan. It's called. And that's the restructuring. Okay, and that's where you go in, and I saw this often even before 2005, where debtors might get medical debts, and oftentimes that would happen, and even with insurance and whatnot, sometimes they were just awful, and they couldn't pay the lump sum, obviously, and the hospital or the doctor, whoever might be demanding the lump sum, and so the debtor then could file a Chapter 13, and the court then would basically set up a restructuring of that debt and allow the debtor to pay it off over time. Okay, so again, another one of those reasons I'm not always as opposed to bankruptcy as you might think, being a former banker. Chapter 11 is similar to 13, but it's for business. Okay, again, and sometimes businesses, you might end up having a lump sum payment due. Maybe it was a contract you had and something comes up and you can't make that lump sum payment. A Chapter 11 allows you to restructure that. There's been big corporations that have gone through Chapter 11s. Some that we're familiar with are Energy, for example. A supplier here in Havre, Northwest Energy, went through a Chapter 11 bankruptcy. It's been probably 10 years ago now. Kmart, of course, Kmart's about ready to do it again, / Sears, that's a whole long story, but it went through a Chapter 11 bankruptcy. little bit dated, but it kind of shows you some of the bankruptcies. And there's the change, right, in that 2005. So you had bankruptcies, people were using and abusing the law the way it was, and the change came into effect. And look at the personal or consumer bankruptcies and how they decreased. Let's get Chapter 7. I kind of already hit these, but just briefly. Again, the assets are put in the hands of the trustee who liquidates them. Again, it's oftentimes these are debtor in possessions. The debtor will line up an auction sale, for example, and they're better off doing it than a trustee that knows nothing about the debtor's equipment or those types of things. So, some non-dischargeable debts, and these are worth talking about. Paternity, okay, you can't get off, or maternity, right? Child support is what we should call it, okay, versus just paternity. Alimony or maintenance, basically the same name or different name for the same thing. Okay, and others. Student loans are not dischargeable. Okay, IRS debts, not dischargeable. Okay, things that you can exempt. Okay, residence, vehicle, household goods, jewelry, especially things that might be sentimental. Tools that you might need, okay, for your trade, or even just general tools that they're not going to force you to liquidate your Leatherman because you might use it around the house a bunch, right? Life insurance can be. Okay, cash value they might force you to take, health aid, Social Security benefits, some other things, right? But do you get to quit paying for them? No, if you keep your vehicle in your residence or other things maybe that you owe money on, in order to keep those, you're probably going to have to continue to make payments on them, even in a Chapter 7 liquidation. We've had that one. 13, again, they're not liquidated, placed under the court's control. Creditors are paid. Sometimes in full. In a 13, they can eliminate some of the debt and just make payments, over a remaining balance. And 11 is for businesses. So additional consumer protection things, right? Fair Credit Billing Act, this is important, right? Limits liability for $50 in lost or stolen cards if you report them within, I think it's 24 hours. Electronic funds transfer, again, limits the liability $50 on lost or stolen ATM cards. So again, but if you report them. Okay, consumer product safety protects consumers from unreasonable risks. Okay. They created the Consumer Product Safety Commission. Warranty acts has to do with both implied and actual warranties that are put on products and how they write them up and whatnot. Food, drug, and cosmetic acts. Some other things that probably aren't going to be on your test. So privacy provisions in consumer law. So Privacy Act 74 restricts how certain info gained by feds. So that's become more interesting, with the Patriot Act and other things, and this mass collection of data that are NSA, National Security, whatever, gets, okay, and how they can use that. But boy, it's a changing world. I'd like to say that it still fits, but we've got such a changing world with what's going on and what's happened with terrorism and whatnot. Right to Financial Privacy Act, government agency. And this is kind of like HIPAA or FERPA or any of those other things in the privacy that you have with your information. Electronic communication targets government agents again seeking information. That's 86. Again, boy, yeah. Some of that I'm a little bit concerned that we're not as concerned about as we are, but Children's Online Privacy Act, so online data regarding children under 13 unless there's parental consents. Cookies, EU's banned cookies without consent. I don't know that the USA has thought about following, so this is interesting. Employers may monitor your email and other computer use at work. They have every right to do that. Voicemail and telephone usage is still protected, but it can be restricted. Okay, they can tell you that the phone that you have at work is only for business use. Okay, they can restrict that. They have a right to do that. Okay, that's a good question. So what's left? Ooh. And there you have it, Chapter 18.